Hello and welcome to the Arbitration Conversation. So in this episode, this will be a really interesting, great episode, another rock star in arbitration, Professor Kristen Blankley. She's at the University of Nebraska College of Law, and her areas of research include arbitration as well as mediation, and she is an active mediator and arbitrator. Thank you for being here, Kristen.
Thanks so much for having me on.
Well, I'm super excited because right away I had been looking at the latest scholarship and I ran across your article. Your article is creating a framework for federal, creating a framework for federal agency rules regarding arbitration. I know I messed up the title. Can you please tell me the title again?
No, you're right. And it is creating a framework for examining federal agency rules impacting arbitration. So the purpose of the article is to really look at what is the role of federal agencies in regulating arbitration.
How does that work? So if you could first just give us all a little bit of background for those watching on how that works with the Federal Arbitration Act. So of course, we all know about the Federal Arbitration Act passed in 1925, but how do federal agency rules then work within that framework?
Yeah, and I think that it tells a compelling story for those of us who think that I like to understand what's going on in arbitration today by looking at the development of those trends. And so without going into too much history, you know, Amy, as you mentioned, the Federal Arbitration Act has been around and largely unchanged since 1925, so 95 years. And in the 80s, of course, we saw a huge explosion of the use of pre-dispute arbitration agreements, particularly in areas that we assume that Congress wasn't thinking about, or at least we have no evidence that Congress was thinking about individual employees as well as consumers and other types of what we call one-shot players, which could include franchisees and other folks. And so, and the reason I can say that we assume that Congress didn't anticipate this is because it's not in any of the documents from that time, and it wasn't a practice. The practice at the time was business and commercial, and what we have seen is that the issue of arbitration has become politicized, in that while there are certainly faults with the arbitration process, it's not perfect, no process is perfect, but it has become somewhat politicized, and Congress has never been able to change the Federal Arbitration Act in order to meet different needs than those needs discussed and considered in 1925. And because it's become oh, go ahead.
Oh, I was gonna, because I think you're right. I think that's a really interesting and important point. You know, when we think about arbitration and how it does become sort of, we look at the headlines, but then what about sort of these different areas where actually federal agencies do speak to arbitration, or at least dispute resolution processes. For example, the Magnus and Moss Warranty Act with respect to consumer arbitrations under that framework. So maybe you could speak about, first of all, how this works and what are the advantages and disadvantages of a federal agency actually taking a role in regulating arbitration.
Right, and because Congress has been so unable to regulate or otherwise change the Federal Arbitration Act, what we're starting to see in practice is that agencies are starting to look at either regulating or outright prohibiting arbitration within the areas of their expertise. One of the most visible areas dealt with the creation of the CFPB and in the Frank-Dodd Act, and one of the interesting or less controversial parts of the Frank-Dodd Act is that it eliminated the ability for home lenders on primary mortgages to could no longer include arbitration agreements in those documents. And so then the CFPB issued regulations that said the exact same thing. And so agencies in some instances are given explicit authority to create regulations regarding arbitration, and the Frank-Dodd Act is one of those examples where arbitration is mentioned in the legislation, and then the agency goes and promulgates regulations regarding arbitration within that sphere. The places where we're seeing some much closer questions are places where agencies are acting within their sphere of expertise, but do not have explicit authority in their enabling legislation regarding arbitration. And so there was a somewhat controversial case in 2016 when the Center for Medicare and Medicaid issued rulings stating that there could be no pre-dispute arbitration agreements in long-term care contracts, so those nursing home contracts. And immediately a district court in Mississippi said that was not a lawful regulation. Center for Medicare and Medicaid had no authority under its enabling legislation. There's nothing in the enabling legislation that talks about arbitration, and therefore Center for Medicare and Medicaid acted outside of its authority. And I think those are those harder cases. And I don't think that, certainly the Supreme Court, with one exception, hasn't talked about the issue at all. And I think that as more and more agencies want to look at or want to regulate arbitration within their own sphere, I think it might be necessary for the courts to take a systematic look and a real hard look at how they can do that and under what authority.
So what do you think? I want to pick your brain how this should work, and especially with respect to other things you've discussed in your article, but because I've actually written on it as well with the Magnus-Moss Warranty Act. Maybe you want to explain a little, because that's one of those cases where you don't have explicit authority under the Magnus-Moss Warranty Act to allow for regulation, but nonetheless, there's some room to maybe read the law to allow it. Maybe you want to speak to that, or what you think. I mean, should there be room to allow for agencies to somehow regulate consumer arbitration within the Magnus-Moss Warranty Act?
One of the things that, and I don't know if I'm going to, I'll get to the Mag-Moss Act. As I was thinking about this, I was really trying to come up with the policies that are at play regarding this highly academic kind of question. And I put together really two frameworks of how should a court go about, what should the test be if a court needs to look at an agency regulation and determine whether or not that agency regulation should stand. And I think that there are two approaches. And the first approach would be one where we take the enabling legislation for the agency and we compare that with the FAA, because at some level, I think that this analysis is analysis that has some relationship with the analysis we've been using for really since 1980, about 84, when the Supreme Court issued rulings regarding what we should do or how courts should interpret statutes, federal statutes. So if there's a federal statute that impacts arbitration, how should the courts look at that to determine whether or not Congress could regulate arbitration? And over time, what we saw in that line of analysis is that, and the most recent statement on that question comes from that Epic Systems versus Lewis case from just a few years ago, where the Supreme Court said that the person opposing arbitration has to show a clear and manifest, which was new language, clear and manifest, contrary congressional command based on primarily the statute of the text of the statute, or maybe the legislative history and maybe the purpose of that legislation. And so I don't think we can ignore that line of jurisprudence. the line of jurisprudence regarding this contrary congressional command. And when we take that into consideration, it potentially hampers agency creativity. And so while there might be some good reasons for allowing agencies who have expertise in particular areas be able to make rulings or cases regarding that impact arbitration, what I am concerned about is whether they have the authority by statute to do so. And so one of the things that I propose in my paper is that, and this is after looking at arbitration policies, legislative policies, administrative law policies, separation of power policies, that perhaps, it's certainly what I anticipate. What I anticipate is that the Supreme Court, if it were to look at this on all fours, would apply the contrary congressional command test to the enabling legislation to then determine whether the agency had authority in the first place. And I do think that there are significant policy reasons that we would want to use, where we would want to use that, even though it does have that downside of losing out on perhaps the nimbleness of an agency to really study something within its area of expertise, and as well as to maybe move more quickly, and especially given total congressional inaction.
But so back to kind of the question of application with your framework. So if we took that and we apply it to the situation of the Magnuson-Moss Warranty Act, I wonder if you had any thoughts on what you think would be the best way to analyze that question.
Right, and the Mag-Moss situation is a difficult one in and of itself, and I'd be interested in your thoughts, because that particular legislation talks about dispute resolution, but it doesn't talk about arbitration, and it talks about informal dispute resolution, and so I think that there's significantly more wiggle room in the Mag-Moss cases than there is in the Medicare situation, or in another area we're seeing involves Department of Ed, and whether Department of Ed can regulate within the area of student loans. And so I do think that in the Mag-Moss section, in the Mag-Moss question, because the FTC was given some authority regarding dispute resolution or informal dispute resolution, I think that the case is significantly stronger to say that they can, in fact, regulate arbitration, because Congress told them that they were to have some control and some authority over dispute resolution. I'm curious your thoughts on that particular question.
Yeah, I mean, I think it does give them. I think as soon as I read your article and thinking about your framework, that question, of course, comes to mind, because it is one of the more interesting questions, because it is this kind of ambiguous. They talk specifically about dispute resolution, so the FTC seems to have the authority, but of course what's been read so far in the courts is that they only gave regulations with respect to quote unquote informal dispute resolution, which is not the same thing as arbitration under the Federal Arbitration Act in the way that it's been read. But I suppose that they could regulate. And I was thinking about what you say in your paper, and again just now about like creativity. So do you think it's a good idea? I mean, what would it look like if we did allow for agencies to kind of take more ownership in those specific areas? You just talked about education, or with Medicare, Medicaid, or these different areas where they actually have a lot of expertise as agencies.
I actually think that would give a lot of opportunities to agencies, and I also think it would give legislatures a lot of cover. So one of the interesting things that we saw politically a handful of years ago was when sweeping reforms could not be made to the Federal Arbitration Act, we started to see very small niche areas of reform. So we saw some prohibitions on pre-dispute arbitration agreement in employment contracts if they are defense-related contracts. There was, I was really surprised when in fact there was no, when Congress did not pass a law that would bar pre-dispute arbitration agreements and telecommunications. And I do think that that's still an area, one of those niche areas that there might be political will to say, okay, all of our cell phone contracts maybe shouldn't have all binding arbitration agreements. But I don't know if anybody's thinking about or thinking politically about as we are crafting and delegating to agencies what it is that they should do, giving those agencies the ability. And I think that there's a lot to that. And we did see this actually in the Frank-Dodd Act, right? And the Frank-Dodd Act created the CFPB, and it charged it to study arbitration, to come up with regulations about arbitration. And so while it's being done with the creation of new agencies, it will be interesting to see whether or not Congress might tell an agency such as the Department of Education, we want you to have the ability to think about, to study and regulate arbitration within your sphere, even if it wasn't in their original enabling legislation.
Well, and of course, one of the most interesting sort of twists within this whole discussion is what happened in 2016, which is when, of course, we saw the Consumer Financial Protection Bureau come forth and issue a regulation precluding the enforcement of pre-dispute arbitration clauses where they would cut off your access to a class action in consumer disputes. And that was within their authority, but then, of course, the ruling that the proposed rule was reversed under a congressional vote. So that's kind of an interesting twist, but it goes back to what you were saying. I mean, once you give that authority to an agency and then that agency actually studies it and comes forth with a rule, maybe we ought to allow for that sort of creativity based on research.
And I think it's not just, I mean, part of it is creativity, and part of it also might be speed. I don't know for certain. I mean, if we had a research component, right, we're going to slow things down. But agencies theoretically have the ability to move quicker than Congress. And so there are additional benefits. And then if Congress explicitly gives agencies the ability to regulate arbitration, then those agency actions are afforded protection under the Chevron principle and other principles dealing with agency deference. So the downside, of course, is that executive branch agencies can be subject to political whim. And because of that, it's possible that agency regulations would be undone. And we've seen this in the Arbitration Act. And one of the things that my paper talks about is, and granted, I started this paper under the Obama administration, and one thing led to another, and the paper's only now getting published in 2020 under the Trump administration. And when I started writing this paper, the idea of agencies regulating arbitration was being done, was a very active pursuit. And at first that regulation regarding the nursing homes, as soon as it was challenged in Mississippi, that legal case came out or was decided right around the change of administrations. And when the Trump administration took over, that particular regulation was taken off consideration. And so it was scrapped by Center for Medicare Medicaid. The Center for Medicare Medicaid ultimately came up with a different regulation. And this is one that says that there can be pre-dispute arbitration agreements in nursing home contracts, provided that the resident cannot be denied admission on the basis of failure to sign. And so it's a watered down, legally it's a much watered down version, but as a practical matter, I'm not certain it's going to make any difference. I and Amy, I know you've done a lot of research on readability and readability of arbitration agreements and retention of what's in those agreements. And so I have a hard time thinking that as families are making those difficult decisions about long-term care facilities, that arbitration is something that's really something that they're considering.
Right, absolutely. Well, thank you. I have to say there's just a lot to chew on. I welcome people to read the article. It just came out in the WashU Long Policy Journal. Great read, so go ahead, Google it, read it. Thank you, Kristen, for taking time with us. I mean, this is a thorny issue and we don't really have any clear answers, except we know, at least currently under EPIC systems and what we're seeing out of the US Supreme Court, that you're gonna need some kind of authority in the actual statute to allow for agencies to regulate arbitration, at least under current jurisprudence.
Thank you so much. I'm so glad to be here with you all.
Thank you.